Hello dear viewers and listeners, welcome once again to the Supreme Court Historian YouTube channel. We are ready for our second case or second set of cases of judgments to analyze, and these are three different cases seemingly unrelated, but we are clubbing them together for several reasons. Romesh Thapar versus State of Madras, Brij Bhushan versus State of Delhi, and Dr. N.B. Khare versus State of Delhi. All three were decided by the Supreme Court on the same day, 26th of May 1950, exactly a week after the A.K. Gopalan case was decided. There's a reason why I am clubbing these three cases together. They all deal with Article 19 and they all dealt with a petition for the writ of certiorari. So this gives us an opportunity to discuss Article 19 in a little bit more detail, and of course introduce ourselves to this particular writ of certiorari. And apart from this, there is the non-technical common ground that they were all decided on the same day. They were being heard in parallel, as it were, concurrently, and the bench was almost identical in all three. This is the first time that the Supreme Court had a 5-judge bench. That was for the third case, N.B. Khare versus State of Delhi. But anyway, we will get to the details of each of the cases in the forthcoming videos, but we will take a look at the common ground first. Article 19 of the Constitution, placed of course in Part 3, Fundamental Rights, which is a list of freedoms that are enjoyed by the citizens of India, not by non-citizens, only by citizens, and as was decided in A.K. Gopalan, only by free citizens of India, not those who are currently undergoing imprisonment or preventive detention. Article 19, Clause 1, Subclause A talks about the citizens' right to freedom of speech and expression, and 19(1)(d) talks about the citizens' right to move freely throughout the territory of India. Seemingly unrelated provisions, and on the face of it they look like fundamental rights which are not really related to each other, apart from the common factor of the citizen and of a right to do something freely, either to speak and express oneself freely or to move about in anywhere in the country freely. These two provisions will be dealt with in these three cases. The N.B. Khare case deals with 19(1)(d), while the Brij Bhushan and Romesh Thapar cases deal with 19(1)(a). The writ of certiorari is what we will look at next, just for a couple of minutes before we conclude this particular short introductory video. The writ of certiorari is mentioned in two places in the Constitution. It is mentioned in Article 32, which is the fundamental right given to any person to approach the Supreme Court in case any other fundamental right is being violated or infringed upon. The writ of certiorari is also mentioned in Article 226 of the Constitution, which talks about the jurisdiction of the respective high courts of each of the states. Each high court possesses this power of issuing a writ of certiorari, and along with the others, habeas corpus, mandamus, prohibition, and quo warranto. We will discuss these writs as we hit upon cases that have mentioned those, just as we are discussing certiorari in this set of cases. A quick word on the term writ. The word literally is means direction or a directive or an order. It is almost synonymous to all of those words. That is what the word writ implies. So when you are seeking such an order from the higher judiciary, either the High Court or the Supreme Court, you petition for a particular writ. Your prayer before the court has to specify which writ it is that you are seeking. And in these three cases, the writ petitioned for was that of certiorari. Certiorari is a writ issued by the higher judiciary to a lower court or to any other judicial or quasi-judicial body under whose jurisdiction those particular judicial or quasi-judicial bodies are. So you approach that particular High Court or the Supreme Court. Supreme Court, of course, has jurisdiction over absolutely everybody, but the High Court's jurisdiction is usually restricted territorially to that particular state and or union territory. So that is about the jurisdiction of to whom a writ will be issued. The jurisdiction as far as the subject matter is concerned is easily divided into three portions. When a judicial or quasi-judicial body has exceeded its jurisdiction in issuing some order, or it does not possess the jurisdiction under which it has issued an order, then the person or entity against whom that order has been made can approach the higher judiciary seeking this writ of certiorari. The next category under which a certiorari writ can be issued is that of the violation of procedure established by law, for example, and or the violation of the principles of natural justice. Let's spend a couple of moments on this, because the principles of natural justice are something that we are hitting upon for the first ever time. These usually deal with the right to a free and fair trial. That is basically what natural justice implies, and this includes these three categories. The first being the right to be heard. The Latin term is audi alterum partem, hear the other party. Unless you hear both parties to a particular case, you cannot pass any judgment. If you have not heard one party, then that judgment can be held to be void. The second is to dealing with bias. If you are a judge who is biased in that particular case, if you have a stake in that particular case, then you cannot or should not pass judgment in that particular case. So this is basically what we can say exists even without any law or any constitution being in place, hence the term natural justice. The third category is that of error of law. In case there is an error of law on the face of the record, that is, if one of the lower judicial or quasi-judicial entities has made an error in interpreting a particular law and passed an order based on that incorrect interpretation, in that situation as well, there is room for asking for a writ of certiorari. I should mention here that in case you want to approach the Supreme Court of the United States, this is the only writ available to you. The judiciary in the United States is also federal, whereas the judiciary in India is unitary. All courts are below the Supreme Court, below which there are all of those 20 odd high courts, below which each of which are all the district courts in that particular state, and also the tribunals for the particular subject matter, below which are the lower causes courts and circuit courts, etc. So all of this is a unitary, it's almost a pyramid in the Indian judiciary. The judiciary in the United States, on the other hand, follows a very different structure. Each state has its own Supreme Court, and there are state laws and federal laws. The federal laws fall under the jurisdiction of federal appeals courts in each state, and then from there the appeal lies to the Supreme Court. And on the other hand, if there is a state law which needs to be examined by the US Supreme Court, it cannot be done unless a writ of certiorari stands or is available. The term you will always encounter when a writ of certiorari has been petitioned for is the term quashing a particular order, even quashing an FIR, which is a more common thing, especially these days when it seems to have become a practice to harass a particular person by filing multiple FIRs against that person in several places, in multiple states even. Then if you are suffering such an harassment by the state authorities, the writ available to you would be certiorari. FIR, of course, is a first information report, which is basically what is noted by the police at the police station when somebody approaches them to make a complaint. So if multiple FIRs have been filed for the same claimed offense, then you can approach the higher judiciary for a writ of certiorari. Or even if an incorrect FIR, an unnecessary FIR has been filed when no crime or offense has been even prima facie committed, then too the writ of certiorari will lie. In our three cases, the writ of certiorari was petitioned for slightly different reasons. In Romesh, Thapar and Brij, Bhushan, it was 19(1)(a) being violated, that was the claim, and 19(1)(a) of course being the right to freedom of speech and expression. Romesh, Thapar and Brij, Bhushan were publishers and printers of their respective magazines, Crossroads and The Organizer respectively, and those respondents, State of Madras and State of Delhi, had prevented the circulation of those magazines in their jurisdictions, in the jurisdiction of the State of Madras and in the jurisdiction of the State of Delhi respectively. Dr. N.B. Khare's case, on the other hand, was that of an externment order. Externment, the vernacular term for that is, of course, tadipar. Because of the speeches that Mr. Khare was making, he was ordered to leave the territory of Delhi for a period of 3 months, and that was the order that he was contesting in that particular case. All three, as I said, were decided on the same day, and chronologically those are the three cases that come up next. The same day is just a coincidence. More importantly, all three deal with the writ of certiorari. All three deal with Article 19 of the Constitution. So we will look at these three cases in the next few videos, and of course there will be a separate playlist for them, for all of them in one playlist. So hope to see you then when we discuss these cases in detail. Thanks for listening. Bye bye.